points that concerned her. One, the question, section under 15.2 about no liability being found, and the section 15.3, I believe, about the name not disclosed. With respect to no liability be found, I'd be interested in knowing whether the honourable member would agree that it's important that an investigation of this nature not in any way be seen to impede or taint any criminal investigation, so that liability can be found in the appropriate place. And I'd also be interested in her comments with respect to the provisions of the Act which allow for publication in appropriate circumstances after applying to a court, so that the court can actually look at to see who else's rights might be affected by a disclosure, and whether she doesn't believe that the provision which says that the name will not be disclosed in the report is a safeguard, understanding that that particular child is dead, but understanding that disclosing that child's name would disclose status with respect to the rest of the family and perhaps other children and others that might be affected. And therefore, it may be more appropriate to actually have the application process for the publication of a name in appropriate circumstances.
The honourable member, if you wish.
Thanks very much to the Minister for the question. To respond to his first question, did I agree that the advocate shouldn't do anything that would impede a later legal finding or any kind of further legal process? Yes, but in a lot of cases there is no further legal process. So I just don't want to see this kind of disappear into the ditch where we don't get any conclusive findings from the children's advocate, and it never goes any further. So what did we learn? It's not there, right? So I think there has to be some conclusions that are found by the advocate. And yes, I agree it shouldn't impede any legal findings, but you know, a lot of times you don't have legal findings. So how does that get balanced? I guess I'll throw that question back at the Minister. I'm not clear on the publication ban because I actually haven't been able to read enough about that to understand where it comes into play. Yes, as you know, I'm very interested in privacy rights. I'm very interested in who is holding information about who and who else gets to see it and for how long it's kept and all the rest of that. My concern is that we fail to learn the lessons and we fail to share the lessons that we've learned if we make a child nameless. And I'm hearing the difficult situation that's presented, because if you go out there and say, you know, Johnny B., who died in this manner, a number of people would be able to connect that one way or another with the Black family who had a child die in a certain way, and would be able to figure this out, and therefore the taunts aren't transferred to the child no longer there, but to siblings and parents and people associated with the family. But to be honest, you know, if a child died outside of, wasn't a ward of the government, wasn't under government care, and they died in a playground accident or those aren't accidents, a playground mishap or disturbance or event, or in a motor vehicle collision, their name would be shared, but their family is still out there, you know, with people knowing that somebody died in a certain way, connected with their family, and they deal with that. So I think we've got to weigh this very carefully, and I'm not sure if we've weighed it enough in what I'm seeing in this bill. But that's my hesitation around this, and I will look carefully as debate moves forward to see if it's been answered. And just to refresh the Minister's memory, the other question that I had was the section, sorry, I'm just flipping backwards here. Under Section 8(3), the exemptions that are listed about the advocate, the Standing Committee can order that regulations under the Financial Administration Act or under the Public Service Act does not apply to the Office of the Child and Youth.
Thank you very much.